Welcome to the Deep Dive, your shortcut to being well-informed. When we think about ancient Greek justice, Socrates usually comes to mind, right?
Almost always. That dramatic trial, the hemlock,
Yeah.
it's a powerful image.
It is, but focusing just on that, well, it kind of misses the bigger picture, the everyday workings of Athenian law, which were, frankly, revolutionary.
Absolutely. It masks this huge, quite complex legal machine that was running Athens. Understanding their courts is fundamental to understanding their democracy, really.
Okay, so let's unpack that. Today we're doing a deep dive into the actual mechanism of Athenian justice, not just the famous cases.
Right.
We're looking at the daily procedures, the specialized courts they had, and the really radical democratic ideas behind it all.
How they actually handled offenses, who had the power, and crucially, how different it was from, say, Rome later on.
Yeah, exactly. So what are our sources telling us here?
Well, they give us a pretty good roadmap. We can track how the system evolved, from early reforms all the way through the big political changes in the 5th century.
And specific things, too.
Oh, yeah. We get details on things like homicide cases, the unique rituals involved. It shows a real dedication to process. And comparing it to Rome really highlights the Athenian approach, especially regarding social status and punishment.
And here's the kicker, the really fascinating part for me. We always talk about Athenian democracy in terms of the assembly, citizens voting, political stuff. But the sources suggest the real power, the absolute bedrock of the demo's power, was actually in the law courts.
That's where it was sealed. Ordinary citizens, chosen by lot, paid for their time. They were the ultimate judges, sovereign.
Incredible. So how do they get to that point? Let's trace that evolution.
Okay, so to really appreciate how radical the final system was, we have to start way back. Before Cleisthenes, end of the 6th century BC, it was anything but democratic then.
Right. Political power was very restricted.
Hugely unequal. It wasn't just about money, though that played a part. It was fundamentally about your family origins, your tribe.
The sources mention the 4 old Ionian tribes, the Gentes or Phratries.
Exactly. If you weren't part of those old established groups, you were politically limited. You might be a citizen, sure, but access to high office? Forget it.
So you could be wealthy, contribute a lot, but still be on the outside looking in, politically speaking.
Pretty much.
Yeah.
You were often on the same political level as the poorest class from Solon's census, the Thetes. You had basic legal rights, could go to the assembly, but the real power levers were out of reach.
And this created tension, obviously.
Big time. Because earlier reforms, Solon's policies, had actually encouraged skilled people, tradesmen, settlers from elsewhere, to come to Athens.
So Athens was growing, becoming more prosperous, but more and more of its successful residents were politically excluded.
Precisely. You had this growing group of contributing, sometimes wealthy citizens who were shut out of the traditional power structure. That kind of tension definitely fueled instability, helped pave the way for the tyranny under Pisistratus.
Which sets the scene perfectly for Cleisthenes. His reforms weren't just minor adjustments, were they?
No, they were a constitutional earthquake. He didn't just tweak the 4 old tribes, he smashed them, politically speaking.
And created 10 new ones.
10 new tribes, yeah. Based on territory, mixing everyone up across Attica. Your membership in one of these new tribes became the basis for political life. It completely dismantled that old system based on birth and lineage.
Okay, so that's the political foundation for democracy laid. But the courts, did power shift there immediately?
Not instantly, no. The old institutions held on for a while. The top magistrates, the 9 archons, they still had quite a bit of judicial power. And eligibility for being an archon was still linked to the qualifications for the Areopagus.
Ah, the Senate of Areopagus, the old guard, essentially.
Exactly. Composed of ex-archons, holding office for life. It was this ancient, powerful, conservative body. It had broad, if maybe vaguely defined, powers to oversee laws, state morality. It was a major check on popular will before the democracy really kicked in.
Until Ephialtes and Pericles came along in the mid-5th century. If Cleisthenes laid the groundwork.
Ephialtes and Pericles basically finished the job, and it was a fight. Ephialtes in particular went directly after the Areopagus.
What did they actually do?
This was the radical culmination. They stripped the archons, and basically all magistrates, of nearly all their judicial power. They could only impose tiny fines, maybe 50 drachmas, something nominal.
Anything serious had to go elsewhere.
Correct. It had to go to the people. This is a huge shift. They fundamentally believed that judicial power in the hands of magistrates, who were usually elite, was incompatible with true democracy.
Equality under the law meant the people had to judge.
Precisely. And the Areopagus itself, its power was drastically cut back. It was left with jurisdiction only over homicide cases.
Just homicide. Why?
Well, we'll get into that. But it likely reflects the really special, sacred, almost ritualistic status of killing in Athenian thought. But all its other broad oversight powers, gone, transferred effectively to the citizen body.
Okay, so if the magistrates and the Areopagus are sidelined, judicially speaking, where does that power actually go? How did it work?
It went straight to the demos, to the people. The new system relied on these popular courts with huge juries, the dicasts.
Dicasts, jurors, basically.
Citizen jurors, yes. Chosen by lot, often in massive numbers, 501, 1001, sometimes even more. That was to make bribery or intimidation really difficult.
And these citizen judges decided pretty much everything.
Almost all judicial business, yeah. They held the state sovereignty in their hands, quite literally.
And crucially, they were paid.
Yes. That's perhaps the most radical part. It wasn't much, maybe 3 obols a day, but it's enough.
That's for whom?
Enough for the poorest citizens, the thetes, the day laborers, to actually afford to take time off work and serve on juries. It meant the courts weren't just for the wealthy or leisured class. They were truly representative.
So, stripping magistrates' power, paying citizen jurors.
Yeah.
This completes the democratic picture, according to our source.
Pretty much. That, along with establishing the nomotheti.
Right. The nomotheti, what was their role again? Lawmakers.
Yeah, lawmakers, but maybe better thought of as law reviewers. They were also citizens chosen by lot. If the main assembly wanted to pass a new law or repeal an old one, the proposal had to go to the nomotheti for scrutiny first.
So a check on the assembly, preventing impulsive lawmaking.
Exactly. It provided stability. The assembly could be swayed by rhetoric, by emotion. The nomotheti acted as a kind of legislative brake, ensuring the fundamental laws weren't constantly being chopped and changed. It balanced the radical judicial power of the dicasts.
It's a fascinating balance, mass citizen power in the courts, but a more deliberative, randomly selected body overseeing the laws themselves.
And it worked. The sources note that after these reforms were locked in, there were no really major constitutional changes until Macedonia came along much later. The structure was incredibly resilient.
Okay, so that's the structure. Now, how did it actually function day to day? And here we hit something that feels really alien to us.
The reliance on private initiative. It's fundamental.
It's hard to get your head around. No director of public prosecutions, no crown attorney, nothing like that.
Nope. Not even for really serious public crimes like treason or corruption.
So if someone wronged you or you thought someone had harmed the state?
It was on you, the private citizen. You had to bring the case, the dika for a private suit, the graphi for a public one. You had to argue it, prosecute it, see it through. The state just provided the court and the jury.
And you were supposed to argue it yourself, ideally. No lawyers.
Well, technically, yes.
Yeah.
Though we know professional speechwriters, the logographers were definitely a thing. They'd write the speeches for you. But the performance of arguing your own case, standing before your fellow citizens, that was considered important, a democratic virtue.
Showing your commitment, your public spirit.
Exactly. Justice came from the people, so the people had to be the ones driving it forward.
So even an official, like an archon, if they brought a case that wasn't directly tied to their official duties?
They often made a point of saying, I'm doing this as a private citizen, motivated by patriotism or public concern, philotemia. The state didn't have a default prosecution team.
Except for one specific instance.
Right. There was a board called the Sunagoroi, public advocates. But their job was very narrow.
Which was?
Prosecuting officials at their euthunai.
Ah, the euthunai. Explain that.
It was the formal audit, the review, that every official had to go through after their term ended. They checked for financial mismanagement, abuse of power, any wrongdoing in office. It was serious.
And the Sunagoroi were there to make sure that review was thorough, acting for the public.
Precisely. They were the state's mechanism for accountability after service. But they didn't handle regular public crimes happening in the city day to day. That was still up to individual citizens.
This system, driven by individuals, it must have meant that personal feuds and political rivalries were constantly spilling into the courts.
Absolutely.
Yeah.
Which brings us to this really interesting, maybe slightly dodgy example of legal maneuvering, stretching the law, specifically a procedure called Areopagus.
Areopagus, what does that mean?
Literally, it means leading away, summary arrest. It was meant for catching criminals, red-handed thieves, kidnappers, certain immediate threats. Very fast, very direct.
But people used it for other things it wasn't designed for.
The sources strongly suggest they did. especially in the messy aftermath of political conflict, like after the 30 Tyrants.
We have examples.
Yes, the cases of Menstratos and Agoratos. Both were accused of homicide, often linked to those earlier political struggles.
Wait, homicide? Why weren't they tried in the special homicide courts, like the Areopagus? That seems like the obvious route.
But that would have been slow, complex, ritualistic. And crucially, it might have run straight into the amnesty of 4032 BC.
The amnesty intended to draw a line under the civil conflict.
Exactly. But some people wanted revenge, amnesty, or no amnesty. So the suggestion is they used apogoge, illicitly stretching it.
How? What was the argument?
They basically claimed these guys weren't just historical offenders covered by amnesty, but were ongoing common criminals, kakurgoi, caught in the act right now. It was a way to bypass the proper homicide procedure, bypass the amnesty.
And demand immediate judgment.
Yes. Summary arrest, quick judgment, often execution. It was incredibly aggressive, very hard to defend against once the accusation was made using that specific procedure. It shows how this private initiative system, while democratic, could be twisted by intense political hatred.
Wow. So a system that really valued procedure but also allowed for these quite brutal procedural shortcuts driven by personal agendas.
It's pure Athens, isn't it? That tension. But we should remember, amidst all this high drama, most everyday disputes probably didn't end up in these huge jury trials.
They had other options.
Yes, public arbitration was very common for private suits. Things like contract disputes, property issues, inheritance cases were usually an exception, too emotionally charged.
So arbitration acted as a kind of first stop, a way to resolve things more calmly.
Definitely. The arbitrators were older citizens, 60 plus, chosen by lot. If both parties accepted the arbitrator's decision, that was it. Case closed.
Cheaper too, presumably.
Almost certainly. Less confrontational. If you rejected the arbitration, then your case would go to the full court, that die casts. It was a practical way to filter out disputes, to release some pressure from the main court system.
Okay, let's turn to homicide then. Because here, the Athenians seemed to abandon that mass jury model almost entirely.
They did. It became incredibly specialized, deeply ritualistic. Even after the Areopagus lost most of its power, homicide stayed under a separate system, overseen by the basileus, the king archon.
Why the special treatment?
Because killing someone wasn't just a crime against the person or the state. It was seen as causing religious pollution, miasma.
Miasma, we mentioned that earlier, a kind of spiritual stain.
Exactly, a stain that could affect the whole community. So dealing with homicide required these ancient, specific procedures and separate courts to purify the city and satisfy the victim's family's need for justice.
And it started with a public declaration, a proclamation.
Yes, going back to Draco's ancient law code, the Prytaneion, a formal proclamation against the accused killer.
And by the classical period, there were two proclamations.
That's right. It was a staged process, making the accusation and the state of entity increasingly public.
Who issued the first one?
The victim's relatives, traditionally maybe at the graveside or, as the sources say, on agorae basically, in public. This publicly marked the accused, banning them from temples, from the marketplace, making them a ritual outcast until the trial.
And the second proclamation?
That came from the basileus, the king archon overseeing the case. This was the state stepping in, formally recognizing the private grievance as a legitimate public concern and channeling the potential for blood feud into the legal system.
This specialization went even further, didn't it? They didn't just have one court for all homicide.
No, not at all. This is where their meticulousness really shines. The Areopagus, as we said, kept jurisdiction, but only for intentional homicide or wounding with intent to kill.
Okay, so what if it was an accident? Unintentional killing.
Then your case went to a different court, the Palladion.
The Palladion. Why the separation?
Because the level of pollution, the intent, and therefore the appropriate penalty were considered different. Unintentional killing was still very serious, often punished by exile, but it wasn't seen as the same deliberate act as murder. It shows a real nuance in thinking about criminal intent.
And then there's the really strange one, the Prytaneion?
Ah, yes, the Prytaneion. This court was for truly bizarre situations, cases where the killer was unknown, or where death was caused by an animal, or even an inanimate object.
An inanimate object, like a falling roof tile.
Exactly. Or a ship's mast that fell, or a runaway cart. In the Prytaneion, the animal or the object itself would be formally tried.
Tried? How do you try a rock?
Symbolically. If found guilty, the object or animal was formally condemned and cast beyond the borders of Attica.
That seems almost comical to us. What was the point?
It wasn't about punishing the object, it was about ritual cleansing. The death, even by accident or by an object, still caused miasma. Going through the legal ritual, condemning and expelling the source, was the state's way of showing it was dealing with the pollution, restoring cosmic order, reassuring the citizens. It highlights how deeply intertwined law, religion, and ritual were.
This ritual precision even shows up in the language used, particularly around seeking vengeance for the victim.
Yes, the terminology is very specific. Our sources show a distinction. The victim, on their deathbed, would use a specific verb, episkeptein. It means to enjoin or solemnly charge their relatives to seek justice.
A powerful, almost sacred instruction from the dying person.
Precisely. That word was reserved for the victim. The survivors, like the victim's wife telling her son to pursue the killer, would use a different, more standard verb like keleuen, simply meaning to command or order.
So the language itself reflects the unique weight given to the victim's final wish.
Absolutely. It shows the legal system formally recognized the almost sacred authority of that dying injunction. The family had a duty, rooted in religion and law, to follow it. It's another layer of that intense specialization.
So we have the Areopagus for intentional killing, the Palladion for unintentional, the Prytaneion for objects and unknown killers, all overseen by the King Archon. It's an incredibly compartmentalized system.
It demonstrates just how seriously they took different types of offenses, demanding specific procedures for almost everything, always accounting for intent, circumstance, and that crucial element of religious pollution.
Okay, we've seen the structure, the procedures, the specialization, but what was the overall effect? Did this system actually bring peace and resolution?
Well, yes and no. The ideology was certainly about equality, justice, the rule of law. But the reality, litigation was often just another battlefield.
Another way to fight ongoing feuds and rivalries.
Exactly. The courts often didn't suppress conflict so much as provide a public stage for it. Think of it less as resolution, more as managed confrontation.
So disputes might be legally settled, but the underlying animosity between families or political factions just continued.
Often, yes, especially among the elite. For them, the courts were a key venue for political warfare. In that sense, you could say the courts failed to create final social harmony. But maybe that wasn't their only purpose.
What was their purpose, then, in that context?
They succeeded brilliantly in channeling potentially violent conflict into verbal argument, into performance. And it was a performance directed at the demos.
The elite had to perform their submission to the people's judgment.
Absolutely. Arguing your case, even with a speechwriter's help, was a public act of acknowledging the citizens on the jury as the ultimate authority. Your reputation, your political career, hinged on persuading them, on demonstrating your civic virtue. It was high-stakes political theater.
And the classic example of this is Demosthenes taking on his rival Midias.
Perfect example. Midias, a wealthy opponent, physically assaulted Demosthenes during a major public festival, the Dionysia, a huge insult.
But Demosthenes didn't just sue for assault, did he?
No, he went much bigger. He brought a charge of hubris. And the accusation wasn't just about the slap. It included claims of bribery, harassment, destroying sacred property used in the festival. The physical violence was the hook for a full-scale attack on Midias' character and his disrespect for the community and its values.
So hubris, it means more than just arrogance or pride, legally speaking.
Legally, yes. It was about intentional acts designed to demean, dishonor, and humiliate another person, particularly another citizen. It wasn't just about causing physical harm. It was about inflicting shame, violating their civic dignity. That's why it was a public crime. It attacked the standing of a citizen, which undermined the democracy itself.
And this concept of demeaning or dishonoring conduct, it extended beyond physical attack.
Yes, the sources are clear. Hubris could apply to sexual misconduct, too. Specifically, when it wasn't based on mutual feeling, but involved using someone, subjecting the passive partner to abuse purely for the active partner's gratification. Again, the core idea was the demeaning, the dishonoring, the violation of dignity.
Okay, shifting gears slightly. We've talked a lot about elite men. What about women, particularly in economic life? We tend to assume they had no power because of the kurios, the male guardian.
That's the legal theory, certainly. The kurios was legally required for major transactions. But like many things in Athens, the practical reality seems a bit more nuanced, especially for older women, particularly widows who didn't remarry.
They could exercise some financial independence.
The evidence suggests they could have significant practical control within the family sphere, yes. We have this fantastic example from one of the speeches.
Tell us about it.
It's about a widow who didn't remarry after her husband died. She was left, the text says, in virtual charge of all the family's affairs. And this wasn't minor stuff.
No.
She personally loaned 1,800 drachmas to her son-in-law. Now, 1,800 drachmas, that's a huge amount of money. Enough to build a small warship, maybe. A massive capital sum.
And the crucial details showing her autonomy.
She kept the loan documents herself, secured with her own seal. Functionally, she's acting like an independent financial agent, controlling significant family assets, making binding agreements. While she might not have been able to write a formal will, diatheka is the technical term, her actions show a level of de facto control that complicates the simple picture of total male guardianship. Practice diverged from strict law.
Fascinating. Okay, to wrap up, let's draw that comparison you mentioned earlier. Athens versus Rome. How does looking at Rome make the Athenian system seem even more distinctive?
It really throws it into sharp relief. The Athenian ideal, however imperfectly realized, was citizen judging citizen, trying to minimize status differences in court. Rome, completely different story. Deeply, fundamentally stratified.
And that played out directly in legal penalties.
Absolutely. Roman law, especially into the empire and the extraordinary procedure courts, explicitly divided society into the honestiores, the upper classes, senators, knights, local bigwigs, and the humiliores, the lower ranks, commoners, laborers.
And the punishments reflected that divide.
Starkly. If you were honestier, penalties were generally milder, designed to preserve your dignity. Things like exile, maybe deportation to somewhere not too unpleasant. If you were a humilior, you faced harsh, often brutal, servile punishments condemned to the mines, forced public labor, opus publicum, flogging, even crucifixion. The law actively reinforced status difference.
Wow. And even where the trial happened differed.
Yes. Think about someone like Piso, a powerful Roman noble, or King Rescaporus, a client king. They weren't hauled before a common jury down in the forum like ordinary folk. They were tried in the Senate House itself.
A trial among peers, reflecting their high status?
Precisely. It was a justice system where rank determined everything, the venue, the procedure, the penalty. That's the polar opposite of the Athenian democratic ideal, where placing judgment in the hands of hundreds of randomly chosen, paid, ordinary citizens was a deliberate attempt to level the playing field, at least within the courtroom.
So, pulling it all together, we've seen Athenian justice wasn't just one thing. It was this unique mix. Radical democracy with mass citizen juries, yes, but also extreme specialization, like with all those different homicide courts. And underneath it all, this constant reality of private citizens driving the whole thing, often channeling their own feuds and conflicts into the system.
Right. It was a system that basically acknowledged conflict was inevitable, especially in a dynamic society like Athens. It didn't try to eliminate it, it tried to manage it, to make it public, to subject it to a democratic, ritualized process.
A system built to channel feuds into a public performance, a judicial ritual, even if the conflict itself didn't necessarily end there.
Exactly. And maybe that's the real democratic genius of it. Institutionalizing conflict, forcing even the most powerful citizens to stand before the demos and plead their case. It constantly reinforced where ultimate sovereignty lay. It provided a kind of stability through managed public argument rather than pretending conflict didn't exist.
Which leaves us with a final thought, maybe a provocative one for you listening. How much social cohesion did this messy, participatory conflict channeling system actually provide? Especially when you compare it to Rome, where status dictated justice. In Athens, in theory at least, the law confirmed your status as an equal citizen judge. The perpetual fight for justice was maybe the thing that held it all together. Something to think about until our next deep dive.